going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you guys are having a great day so far. Happy Saturday. Happy Saturday. I have got a long video for you guys today. I was saying, I said last night and then this morning in my video that I was probably going to cut this into two pieces, but I was able to cut the video down to about an hour and 45 minutes. So we're just going to play the whole thing. So sit back, relax. We've got a pro se jury trial in front of Judge Clark. Judge Clark is out of Bay County, Florida. He's the judge that Judge Van always teases him about his hair. Anyways, let's see, what do I have to say? Not a lot. I did cut a lot out. So most of the stuff I cut out was, the jury instructions, any kind of reading of the law, just things like that. So everything else should be here. I didn't cut out any actual parts of the trial, so we will get all of that. I just cut out the stuff that, we don't really need to watch. And I know it's interesting to some of you, but especially if you haven't heard it before. But I didn't want a 3-hour-long video. I did cut out about an hour and 20 minutes of the runtime. Lone Wolf, thank you so much for the raid. Also, Lone Wolf is the one who supplied me with this video. We grab our content differently. And the way I do it, I would not have been able to grab this entire thing. So thanks to Lone Wolf, he was able to grab it for me. So thank you so much, Lone Wolf, for the video and the raid. All right. You guys ready? Pro se jury trial. Let's go. All right. I need to stop saying let's go right then because I say let's go at the end of this. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Now let's go.
September 4th. Bay County Courthouse Annex Courtroom. A, we have Bay County case, State of Florida versus Frazier, case number 23 CF 2845. Mr. Frazier's present, appropriately dressed out. He is pro se this morning. Ms. McCarthy is present as backup counsel. Mr. Sullivan and Ms. Debro are present as the state. Give me just a moment to log on. All right. And Mr. Frazier, you're representing yourself this morning. We went through that yesterday. Do you understand you have a right to have an attorney represent you? Is that correct?
Yes, sir.
And Ms. McCarthy is present. She picked the jury and she's ready to represent you. Do you still wish to represent yourself?
Yes, sir.
You understand at any time in these proceedings, you can opt to have Ms. McCarthy appointed and she'll be appointed to represent you.
Yes, sir.
All right. Anything we need to take up prior to bringing the jurors in?
There's one issue, Your Honor, based on some things that I've heard on jail calls. I anticipate the defendant is going to try to argue, impeach, or bring up some things that I don't believe are admissible. Specifically, the lead investigator in this case at one time worked in Jackson County. The defendant, I anticipate, is going to try to get into what happened with Zachary Wester, the officer that was planning evidence.
Yes, Mama Wolf. This is Judge Clark. He's got that gray head of hair. That's how you can tell Judge Clark apart from the other judges. His hair is amazing. I'm quoting Judge Van.
In Jackson County. The investigator in this case has nothing to do with that, was not involved in that, but the defendant is going to try to tie this investigator into that. The case law is pretty clear that any misconduct on behalf of the officer is inadmissible in trial unless it specifically relates to this case. So I would ask that the court preclude any testimony and questioning about any misconduct unless it pertains to this specific case.
All right. Mr. Frazier, your response?
All I wasn't gonna actually bring that case up. I was gonna ask the officer, had he ever been in trouble you know, with the law before, like, have he ever been implemented in any cases? I wasn't actually gonna bring that case up.
I'm not sure you can ask that
Because
unless you can back it. I bet Mr. Sullivan,
I
what's the
wasn't gonna
state's
bring it
position
because I
on
know
that?
that's not relevant to my case. So I wasn't gonna actually bring that up because I know Zachary Webster is not irrelevant in my case.
Okay. Sullivan?
So, but I do,
I don't believe that's a proper question. I don't believe it's admissible. To my knowledge, there is no misconduct on behalf of the officer in this particular case, as well as in his career. I don't believe he's had any misconduct issues.
Yes, sir.
I know it's not relevant to my case, like Mr. Sullivan said, but Your Honor, and I know that's not dealing with my case, but Trevor Lee has had trouble with with other law enforcement before, and I have the cases that he's dealing with right now. That he went in Jackson County. That's why he came here from Jackson County, Mariana, Florida.
How are you gonna prove that?
Well, actually, you know, I can prove it because I have the case numbers right here. But I wasn't gonna bring it up.
No, you're not gonna bring it up.
No,
I'm
sir,
gonna
I
grant.
wasn't gonna bring it up. But I was just gonna ask him, have he ever been in trouble before, and why did he leave Mariana? You get what I'm saying?
No,
He
sir, I
has.
don't. I don't get what you're saying at all.
But he has been. Frank Sullivan knows this. He has been in trouble with the law before, and he actually is going through a civil suit right now. You know, and he.
I don't think that's relevant. So basically, I'm gonna grant the state's or tennis motion for motion in limine. You're not to go down that road.
Okay, that's great. That's great. I understand.
All right. Anything else?
I'm from the state on that.
All right, to answer the question of why this is relevant, the defendant is pretty much his entire defense is that the officers are lying. So he wanted to be able to question the officer on a pending case that he's already facing, some kind of police misconduct, I guess, for. We can't talk about it, or they can't talk about it, so I don't know. I don't know what case he's talking about, but apparently there's something going on that he's not allowed to bring up, which, I mean, if his defense is that the officers are lying and one of the officers is currently under investigation, I think that would be relevant, but it was already decided. The defendant filed a motion, and this was actually decided at the final pretrial, so he's not allowed to bring it up, which is why the prosecutor said, I'm afraid he's going to bring this up. He was already told he couldn't. So that's why it's relevant. Okay, let's go.
Mr. Frazier?
I'm ready.
Okay, all right, I am going to give the instruction of pro se defendant. Mr. Frazier has the right to be represented by an attorney or to represent himself in this trial. As to all criminal defendants in this country, he has exercised his constitutional right to act as his own attorney. This decision could not affect the consideration of the case. I'll give that before I give the preliminary instructions. Mr. Frazier, do you wish to have the instruction about your right to remain silent? And this is the instruction I'll give you. If you would like it. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt. And the fact that a defendant did not take the.
All right, I don't mind pausing it here. He's just reading. I thought I cut most of this stuff out, but he has a standby attorney, which is she is sitting right behind him. She's not at the defendant table currently, but she is sitting right behind him. And that's a good question because this does come up. As of right now, he is pro se. He's defended himself.
Witness stand does not influence your verdict in any manner whatsoever.
Yes, sir.
Do you wish to have that read?
You asked me, will I like to be questioned?
No, sir. This is a part of the preliminary instructions,
Yes, you can read it.
and it's up to you whether I read it or not.
You can read it.
Okay. All right.
Good.
Have you got jury instructions?
Yes, Your Honor, I've provided in the.
Okay, the book, and you've already provided, Mr. Frazier.
He's got a copy of the lawyers.
All right, Mr. Frazier, in just a moment, we'll bring the jurors in. At every stage of these proceedings, I'm going to ask, like to have an attorney appointed to represent you. Since you are representing yourself, do you wish to have an attorney appointed today? At this time, but prior to opening statements?
No, sir.
Okay. Do we have the jurors? Very good. Mr. Sutherland, whenever you're ready.
Thank you, Your Honor.
All right, so I just fast forwarded the jury coming in. Again, every time you see the fade in, fade out, I'm cutting out a lot of just dead time. We didn't need to see the jury coming in. I don't want them to be on video anyways, so it worked out perfectly. And okay. Ascalis, yes, absolutely. Feel free to email me or find me on Discord, and yeah, let's talk about it. I always like those kind of stories.
July 26, 2023, a little over a year ago, this defendant was found by members of the Bay County Sheriff's Office in possession of just over 28 grams of fentanyl. You're going to hear from a couple witnesses today. The first one's going to be Investigator Trevor Lee of the Bay County Sheriff's Office. What he's going to tell you is that back in July of last year, he received some information from a confidential source that this defendant was involved in narcotics. There were some phone calls that were placed from the confidential source to the defendant. And when those phone calls were made, Investigator Lee used some police databases to search that phone number and find out who it belonged to. What he found is that the phone number belonged to a man named Jamie Frazier. When he had that information, he searched some more law enforcement databases, and he found out that that man, Jamie Frazier, this defendant, had a suspended driver's license.
Can I object to that, y'all?
No, sir, you can't.
When he realized that the defendant had a suspended driver's license, he was also able to pull up a picture of that person, and he showed it to the confidential source, and he confirmed that yes, that's the person that he was talking to on the phone. At some point in time, the defendant scheduled a time to come meet the confidential source at 3 o'clock. And law enforcement was kind of sitting in the area waiting. And at 3 o'clock, the defendant driving a vehicle pulled up. Law enforcement saw the defendant driving the vehicle, was able to confirm that it was him based on the photograph that they had. And at that point, they conducted a traffic stop and placed the defendant under arrest. Once he was placed under arrest, law enforcement searched his person. And you'll see that in his growing area, there was an abnormal size bulge. And in that location, law enforcement found the contraband, in this case, the drugs that would later test positive for fentanyl. You're going to hear from Investigator Lee. He'll tell you kind of about the first part of that with the confidential source. We'll hear from Investigator Thomas LaRoche. He's the person who actually searched the defendant and found the drugs. And you're going to hear from a person by the name of Paula Vera. She works for the Florida Department of Law Enforcement. What she's going to tell you is that her job is to analyze substances to determine what they actually are. And in this particular case, she analyzed the substance, was able to determine that it was in fact fentanyl, and that it weighed just over 28 grams at 28.35 grams. Now, I want to go over one thing that Judge Clark just told you in those instructions. I know he read you a lot of instructions, and it's something that I normally would have talked to you about yesterday, but because the defendant chose to represent himself after we finished jury selection, I didn't get a chance to. One of the things that Judge Clark told you is that throughout the course of trial, there may be times where either myself or Mr. Frazier, like he did a moment ago, objects. If that happens, like the judge said, you're not to kind of wonder why or what would have been said. There are rules that we both have to follow. I have to follow the rules. Mr. Frazier has to follow the rules. We talked a little bit yesterday during jury selection about some TV shows you may watch. You may have seen the crime show where, somebody objects because of hearsay, for a hearsay reason. Hearsay is not allowed at trial. So if that comes up, just remember Judge Clark's instruction that, there are rules that we have to follow. And those objections basically mean that I think the other side broke the rules. Sometimes they do, sometimes they don't. And the judge will say overruled, and we'll move on. After you've heard the evidence and the testimony in this particular case, Judge Clark will give you more instructions, and that will include the law that you will apply to the facts. What he's going to tell you that for this charge, trafficking fentanyl, I have to prove 3 things beyond a reasonable doubt. The three things that I have to prove are: one, that this defendant, Jamie Frazier, knowingly possessed the substance. The second thing I have to prove is that that substance was fentanyl. And the third thing that I have to prove is that the fentanyl weighed 4 grams or more. And after you've heard the evidence and the testimony in this case, I don't expect it to be a very long trial, but after you've heard all of that, there will be no reasonable doubt, there will be no doubt that this defendant possessed that fentanyl that weighed more than 28 grams, let alone 4 grams. And at that time, I'll come back before you, and then I'll ask you to find the defendant guilty as charged. Thank you.
Mr. Frazier, whenever you're ready.
All right, I am going to try to pause it only during appropriate times. So, Susan, thank you so much. This is an awesome chat. Really nice folks. I agree. The chat is awesome. You guys are awesome. Susan, thank you so much for the super chat. I appreciate it. All right. That was a pretty straightforward opening statement. Now, pro se, let's go.
Actually, it was July the 26th of 2023 when they supposedly found me with fentanyl. I will prove to you today that these officers are dishonest and they will do anything to get a conviction, that those drugs are not my drugs. They will break the law and violate constitutional rights. The sheriff policy code that they took an oath not to break, use undocumented confidential informants that they use. And at the time, I will also prove to you that the picture that he claimed that he took a picture of when I was staying in Florida at the time, that I didn't have dreads. I was in a car with tinted windows. So, and I'm gonna prove these things to you. And I'm also prove to you that he had no knowledge of me until I was booked into the county jail, until they supposedly arrested me that day. I'm gonna prove to y'all that all that is lies. I'm finished, y'all.
Okay.
All right. And one more thing. And they said at first when they caught me, and I had a paperwork that they caught me with 64 grams of fentanyl. Now it's 28 grams of fentanyl. So I'm gonna prove all this to you all.
So they call you first witness.
Some state calls investigator Trevor Lee. I step out.
Yes, sir.
Thank you.
If you come up, stand by the chair and tell the clerk to swear you in.
You solemnly swear or affirm that you're about to give the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Sir, you'll have to speak to the microphone.
Yes, sir.
So then, inquire whenever you're ready.
Let's go. Good morning, sir.
Good morning.
Can you please introduce yourself to the jury?
Trevor Lee,
Where are you employed?
the Bay County Sheriff's Office.
How long have you been?
You don't need an invite. The Discord link is in the description. So if you just check the description of the video, you'll see the Discord link. But I'm sure one of my mods will drop it here shortly.
Employed with the Bay County Sheriff's Office.
2021, I believe.
So about 3 years or so.
Yes, sir.
What do you do with the Bay County Sheriff's Office?
I'm currently a narcotics investigator in the Special Investigations Division.
Have you been a narcotics investigator the entire time you've been with the Bay County Sheriff's Office?
No, sir. I was on patrol for a period of time before that.
How long have you been in narcotics?
About 2.5 years, give or take.
Prior to working at the Bay County Sheriff's Office, where were you employed?
The Jackson County Sheriff's Office.
How long were you employed with Jackson County?
Approximately 6.5 years.
What were your duties, responsibilities with Jackson County?
I was a patrol deputy for a time, canine handler, and then I also worked in the drug task force, which was in investigations.
So you've got about a decade worth of experience at policing, most of it in narcotics. Is that fair to say?
Yes, sir.
I want to take you to July 26th of 2023, a little over a year ago. At some point, were you informed that the defendant, Jamie Frazier, was involved in narcotics?
Yes, sir.
How did that come to your attention?
From a confidential source of information.
At the time, did you know you were presented some information from this confidential source?
Correct.
Did you know who the person that he was talking about was?
Not initially, no, sir.
Did he have some information, or did he or she have some information about a phone number for this particular person?
Yes, provided me with a telephone number.
What did you do with that telephone number?
Using a database that we have in law enforcement, I was able to determine who the phone number was registered to.
Who was that phone number registered to?
Mr. Frazier.
After you were able to determine who that telephone number belonged to, what did you do?
Then using other databases, identified him and confirmed with the source of information that the person that he was speaking to was Mr. Frazier.
And when you say you identified him, what do you mean by that?
I ran him through David or FCIC, which provides us with a photograph.
Okay, so you're able to pull up a photograph of this Mr. Frazier.
Yes.
And you showed that photograph to the confidential source?
Yes.
Did he confirm that that was in fact the person that he was talking about
Yes.
and providing information about?
Correct.
When you ran Mr. Frazier's information through FCIC and David, were you able to determine anything about his driving privilege?
Yes, he had a suspended Florida driver's license.
The person that you, the photograph that you saw for this Mr. Frazier and you provided to the confidential source, do you see that person in the courtroom today?
Yes, sir, I do.
You identify him?
Yes, sir. Sitting there with a red or orange in color shirt.
Let the record reflect that the witness has identified the defendant.
The record will reflect.
So after you identified the phone number as belonging to Mr. Frazier and determined that Mr. Frazier had a suspended driver's license, what did you do?
We then initiated an undercover operation and placed a controlled phone call to Mr. Frazier in reference to bringing us a quantity of narcotics.
And when you say a controlled phone call, that's a phone call that the confidential source places to the defendant.
Correct, in my presence.
You're present and it's on speakerphone so you can hear what's going on.
Correct.
During that phone call, did Mr. Frazier agree to meet up with the confidential source?
Yes.
Was there a time and place that was established?
Yes, about 3 o'clock and at the source's residence.
Without giving the exact location, is that location where Mr. Frazier agreed to show up here in Bay County?
Yes, sir.
So what did you and other law enforcement officers do after those phone calls were placed?
We set surveillance in the area and waited for his arrival, knowing that he has a suspended driver's license. We were going to wait for him to arrive. And
were you involved in that surveillance?
yes.
At some point, did you see Mr. Frazier driving a vehicle?
Yes, I did.
Do you know what type of vehicle it was?
It was a dark colored Nissan, I believe.
Did you run the registration or tag information on that vehicle?
Eventually, yes, sir. It was a California plate. It was determined to be a rental vehicle.
Were you able to see the person who was driving the vehicle when it arrived?
Yes.
Who was driving that vehicle?
Mr. Frazier was driving the vehicle.
Were there any other occupants of the vehicle?
No.
That vehicle showed up to the location that was agreed upon during the controlled phone calls?
Yes.
What about the timing of it? Was it?
Roughly around 3 o'clock.
And that was agreed upon during those phone calls?
Correct.
After Mr. Frazier showed up in that vehicle, what happened?
Myself and other investigators conducted a stop. He was subsequently detained and arrested for the driver's license, as well as unlawful use of a two-way communication device and search incident to arrest.
And were you involved in the search?
I believe Investigator LaRoche was the one who searched Mr. Frazier's person.
After Mr. Frazier was ultimately arrested, did you place a phone call to the number that was provided by the confidential source?
Yes, I did.
What happened when you did that?
A telephone that was in his possession rang, so we believed it to be associated with the phone number that was on his person.
And when you say his possession, who do you mean?
Mr. Frazier's.
So he had a telephone on him when he arrived that corresponded to the phone number that the controlled phone calls were placed to.
That is correct.
I've got no further questions, Your Honor.
Mr. Frazier?
How you doing, today, Mr. Trevor?
Good morning.
Hi, Mr. Trevor, I have a few questions for you.
All right, sorry. I was trying to pause it like 10 seconds ago, but my pause button's slow for some reason. I just wanted to thank Kimmy real quick. Kimmy, thank you so much. Or Kimby. Thank you so much. And I love that you're here. Thank you so much for the super chat. I like talking to you every day. I think we talk almost every day in a court chat, or at least I see you talking. I generally lurk, but I always see you. Thank you.
Have you ever committed perjury?
Objection, Your Honor, will sustain.
All right. Okay, on February the 14th, 2024, you had a telephone deposition, right? With Matt Merritt and Frank Sullivan, the deposition?
I believe so. I believe that's when we did depositions by phone.
Okay. And in that deposition, you told my
Objection,
previous.
Your Honor, improper.
Ms. Chambers, y'all approach, please.
Your Honor, that.
Oh, I forgot to cut this one out. I cut out, I think, 3 or 4 different bench conferences. I missed this one. I don't know how long this is. I don't think it's that long. Otherwise, I would have seen it. I'm going to fast forward 10 seconds. Oh, it's still there. Yeah, I missed this one. Sorry, guys.
But let me rephrase that question.
It's not hard. It's just time consuming. And when there's a 3-hour long video, I'm going to make mistakes. It's probably not the only one that I missed.
Do you remember on the day of deposition that you admitted that you used?
Objection, Your Honor, sustain.
Okay. Well, I'm gonna ask this one then. Did you violate the sheriff policy 4322.04, the sheriff code that required that a confidential form be documented before use?
On that date, the source was not documented.
So are you admitting to the jury that you broke protocol by using this confidential informant?
The source was used the same day that it was developed. It was not an intentional slight to not document the informant.
So you telling the jury that you don't have to document a confidential informant before using him?
I don't believe that's what I said. I said it was not intentional to not document that source of information that we used the same day that it was developed.
So my question is, yes or no, do you supposed to document a confidential informant by the sheriff policy 4322.04 before using them?
That's correct, to use a confidential informant, but this was developed as a source of information.
A source of information. All right, let me keep going. Okay, also, I think Mr. Frank Sullivan had asked you about the two-way communication device, right?
Yes, sir.
And then on the two-way device, do you recall me saying anything or talking to any type of drug codes or anything that would implement drugs?
Without listening to the phone call directly saying yes, I cannot, but it was assumed based on the time when we were outside dealing with the phone call.
What I'm asking you, I want to know, did you, in that phone call, did you hear anything about me implement any drugs or that I was bringing any drugs or anything illegal to initiate a crime?
I believe you, in the phone call again, without reviewing it, but best of my recollection, you advised that you'd be there at 3 o'clock with, I think 2 may have been the word that was used. Again, without reviewing the phone call, I can't exactly quote what you said.
Okay. Your Honor, I would like to impeach him right there, please.
Right here.
Okay, Your Honor. Okay, can you? I want my attorney to play the call first. Okay.
I mean, what are you asking to do?
Because I want the jury to hear this phone call.
You want to introduce it?
Yes, I want to introduce it as evidence.
Yes, Your Honors, my case in chief.
So the jury can't hear the phone call?
This is the state's case. Introduce the evidence. You have to wait till your turn to introduce evidence.
Ma'am, sir?
You have to wait till your turn to introduce evidence.
Oh, I have to wait till I call him as a witness? Okay, great. Okay, well, let me ask you another question then. Okay, you admitted to the DA that you found out about me through the confidential informant, right?
Yes,
And what date was that actually?
the same day of the operation.
Same day of the operation?
Yes.
Okay, I would like to impeach him again also, Your Honor.
You don't have to ask me. You can just go through the impeachment process.
Okay, well, do you remember making a sworn statement in my discovery?
Proper impeachment.
This time.
So I can't show where he lied.
Stop.
All right, I think I caught this one. I always have a problem with how this courtroom's set up. The defendant just walks right behind the witness. I don't like that. Again, very, very slim chance that the defendant would do anything, but the defendant on the podium right next to the prosecutor and walking behind the witness, I just don't like that. It makes me nervous. And clearly I did not catch this one. Did not catch this one.
All
right. I was skipping around trying to find it. This video is so long that even when I try to move the cursor just a little bit, it skips about 15 to 20 seconds. So probably about 5 seconds till this is finished. And apparently I can't count either. What's up, Mayor? Good to see you, bud. He thinks when he's saying, the way that he's saying it is he's trying to call him out on lying. But impeaching, like he's already doing that. The witness is there. He's impeaching the witness. He's asking him questions. So I don't understand why he keeps saying that. But he thinks it means something that isn't true. He's already asking the questions. If he wants to ask, try to catch him in a lie, he's got to ask him the right questions to catch him in a lie, which for whatever reason, he thinks he needs to ask permission to do that. I don't know. Bruce, thank you so much. I appreciate it. Welcome to the family. And it's good to see you, bud.
Also, trouble, have it ever been a time that before the informant, that you say that the informant that you ran across me, where you heard about me through the informant, have it ever been a time before that you said that you admitted that you talked to the informant about me before?
I don't think I understand the question.
What I'm trying to get at is, have you ever admitted that okay, like for example, that I learned about Mr. Frazier days and days before I talked to the informant?
I'm still not. You mean, can you ask it a different way? I'm really not understanding what you're saying.
Have you ever had a conversation with someone saying that you talked to the informant about me before July the 26th?
Have I ever talked to a source of information in regards to you? Is that what you're asking?
Yes. So have you ever talked to the informant before July the 26th concerning me?
No.
Okay. And I would like to impeach, and I would like to use it as evidence.
Ask your question.
Yes.
I can't rule until you ask your questions.
No, I would just like to impeach. Okay. So have you ever made a statement a sworn statement that you talked that you talked to the CI and that you did surveillance on me 21 days prior to the affidavit?
I don't believe I said I'd done surveillance on you 21 days prior to the affidavit.
Well, so I would like to, I want him to read this. May I give this to officer?
You asked him to approach and ask him to read his prior statement.
Yes, can I approach?
Yes, you may.
I'm asking the statement before.
Yes, if you'll just show that to Mr. Sullivan.
I'll let you read this to the jury.
Mhm.
This is small statement.
No, Mr. And I think I heard you ask him to read it to the jury. What you,
I would object to improper action based on.
I'll sustain the objection. You asked him to read it to himself, and you can ask him questions about it.
Okay.
Sir, if you'll just let us know when you're finished reading that statement.
Okay.
So do you admit that on that statement and what you're saying now are two different statements?
That affidavit that you provided me was a forfeiture affidavit, which was wrote days after your arrest for a quantity of currency that was found in your apartment. So that was, but yes, that's what that says.
Well, back up. You said that was about.
Yeah, that's a perfect example of why this defendant needs to have an attorney. He didn't ask that question correctly. Well, he may have asked the question correctly, but he needed to stop the witness from explaining all of that. Because that wasn't what he asked him. Said, is it true that it was different? And the second he started saying, well, what you just showed me is a forfeiture affidavit. It's not what, and I would have just been like, no, that's not what I'm asking you. I don't know what the proper objection is either. But again, I'm not an attorney.
About the arrest in my apartment.
That affidavit that you just presented me is a forfeiture affidavit for money.
Look, back up. I would like to impeach him again. I would like him to read.
You don't have to ask me. You just ask your questions. If there's an objection,
Because-
we'll deal with it.
Okay, you said this about my apartment, but you said right here that you was I can't read it, right?
You can question him about it.
But I can't read it.
Well, you can just ask your questions. If there's an objection, we'll deal with it, okay?
Okay. You said in the statement, okay,
Objection to improper impeachment. Sustained.
okay, all right. On this paper, did you say that you had
Objection to improper impeachment.
prior to the date, so let me put that another sense there. You said it was dealing with going into my apartment, right? But on the paper, you admitted that you got that information from a confidential informant. Am I correct?
The use of the term within the past 21 days is discussing probable cause, which we have 21 days. That probable cause is valid to use information or an arrest or an affidavit.
Okay, but you, in this statement, you said that, I would like to elaborate that.
Objection to improper impeachment.
So you said, so in 21 days, how can you put on the statement that you talked to a confidential source and the confidential source told you 21 days before that I was transporting drugs?
I believe the term is within the past 21 days. I don't believe it says specifically 21 days prior. I believe it says within 21
Okay,
days.
so, okay, but you said, it said within 21 days, but you just admitted that, didn't you say, admit that you ran across me July the 26th, the same day you got me, right?
Correct.
So how is that 21 days?
I believe it would be within 21 days. I think today is within 21 days of 21 days ago.
So, okay, another question. Have you ever seen where a warrant was taken out on someone for a lawful use of a two-way device?
A warrant?
Like, have you ever, like, before, like you said, you knew who I was before I got there, right?
Yes, sir.
So have you ever seen in a case where if you know somebody, if you know who that person is, and they have committed unlawful use of a two-way device, have you ever seen a case where you all will go ahead and take out a warrant on that person before they arrive?
I don't recall taking out a warrant before they arrived.
Okay.
I believe you also had a suspended Florida driver's license as well.
Okay. So, did you have on any body cam?
I did not.
Was it anyone out there who had on body cam?
I don't believe so.
Okay, Your Honor, I would like to also place that in evidence also.
Sir?
I would like to put this in evidence.
What do you ask me to put in that?
The pictures to prove about the body cam.
I object to the timing. You know, if he wants to place anything he wants in evidence during his case in chief, that's his prerogative, but it's not the proper time for him to enter evidence.
I sustain the objection.
So did anybody have on any body cam out there?
I don't recall.
So okay, is it sheriff protocol that you all wear body cam?
I believe at the time it was not any kind of policy or procedure for investigations to wear body cam.
So, so in 2021, they didn't update a policy and procedure. It's 2250.02. Body camera must be worn by Bay County Sheriff officers.
That is probably the policy. I have to review it. I don't have the policy in front of me to know it, but at the time, investigators were not issued body cameras to the best of my recollection at that time.
So what you mean they didn't issue by you saying that y'all never had them or y'all don't
That
have them?
investigations was not issued body cameras. Not saying that deputies on the road were not issued body cameras. I believe we were not at the time.
Oh, okay. So can you explain the situation where you have to wear them to me?
Again, I cannot quote verbatim policy, but at the time, investigations were not required to wear body cameras during operations.
Okay, then. Where was the meetup location at?
Objection, Your Honor. Goes to the identity of confidential informant. The officers testified that it was at his house.
You know, I said I cut these out, and the first three I missed. I must have just been focusing at the end of the video. Man. I promise I cut this from 3 hours and 20 minutes to 1 hour and 45, though. That's true.
Where was the meetup location?
You know what? I can answer a few questions that people have asked. So this was September 4th. So this was 10 days ago. So this was last week. Not this past week, the week prior. Also, someone asked what he's charged with. I believe his charges are drug trafficking because of the amount of drugs he had on him. He's looking, based on what he's charged with, he's looking for at the sentence of a minimum of 25 years. So a minimum of 25 years if found guilty, and he decided to go pro se. And the reason he went pro se is he did not agree with the way his attorney wanted to defend him. His defense is to call everyone a liar. They're all lying. None of this happened. They're all liars. And his attorney wasn't going to do that for him. So that's why he's pro se. Okay, I've seen a bunch of questions come through, and this was a good time to pause. Let's go.
again. What was the meetup location?
Court reporter is ready to go before you ask your questions, okay?
Okay, I apologize. Ready? Okay. Again, where was the meetup location?
The location you arrived at
Where? Like,
in Bay County.
I know it was in Bay County, but like, was it a public place? Was it at someone's residence or church? You know?
You were observed arriving at the meet location at a residence, yes, sir.
Okay. So by y'all doing that, did you violate the confidentiality law of a confidential informant and the Rachel law by putting the informant and his family at risk?
I'd have to review the Rachel's law, but I believe you stayed there for just a second and left. And also I believe the confidential source was not at the residence when you arrived.
Excuse me?
The source was not at the home when you arrived.
Hold up. I didn't say nothing about the source was not at home when I.
Right. I know you're asking me if we put them in danger. I was just letting you know.
I know that, but I'm talking about his family, his mother, his kids. I'm asking you a question. Did you violate the confidentiality law by setting up a sting where a confidential form is supposed to be disclosed where people do not know who they are, right? Am I right?
I'd have to review what law you're referring to.
Okay, you just admitted to the court that you have been dealing in narcotics for a minute now, right?
Correct.
So if you've been dealing in narcotics for a minute, you should know about confidential informant. This is not your first go round. Am I correct?
That's correct.
Okay. So if this is not your first go round, you should know that you should not set someone up or attempt to set someone up at their residence.
Is that an argument?
Stand.
Okay. So I'm gonna ask you again. Did you violate the confidentiality law by setting someone up?
Objection, asked and answered.
Stand. Ask your next question.
Okay. Okay, when you said you identified me, right? Through a database.
Yes, sir.
So in that database, did I have dreads?
They were shorter than they are now, but your facial features were the same.
Okay, in that database, right? That's saying about my old Florida license picture, right?
Yes, sir.
Oh, okay. I would like to impeach him on that, Your Honor, because
Frazier, you don't have to ask.
can I approach you then? I want to say something too. Can we approach the bench? Because this is just.
All right, I think this one I knew I faded that one out. Okay, something really important happened during that approach. He tagged in his attorney. He started getting frustrated and he tagged in his attorney. She was on standby. She was his attorney up through jury selection, and then he decided to go to do it himself. So now he has an attorney. So I think he's too late though, man. I think it's too late, but let's see.
Let's go back on the record. Back on the record. Everyone is present. The jurors are still on break. Mr. Frazier, have you made a decision?
Yes, sir.
And what is that decision?
I'm gonna let this Oral McCarthy take over.
All right, Mr. McCarthy, I am going to reappoint you to Mr. Frazier's case. Thank you for being present this morning. And are you ready to go forward?
Yes, sir, thank you.
Anything we need to put on the record other than that?
Yes, Your Honor, while we have a moment, I would like to, my second witness is going to be Thomas LaRoche. He's going to talk about the drugs that were found on Mr. Frazier. There were multiple baggies that were sent to the Florida Department of Law Enforcement, one of which was tested, the others were not. Typically, I would not introduce those other exhibits or seek to do so because they were not tested, but I believe based on Mr. Frazier's comments during opening statements, that he was going to prove that there were 60-some grams and now there's only 28. But he's kind of opened the door, and I'm asking to the court to make a ruling on the admissibility of those other exhibits. Now, I'm not going to refer to them as controlled substances, was that these were suspected controlled substances that were found at the same time, same location as what ultimately tested positive for fentanyl.
Ms. McCarthy?
Yes, sir, I understand that, Mr. Frazier opened the door to that, so that's fine, as long as no one's gonna say that it was tested.
No, I don't anticipate doing that yet because I can't say that.
And for the record, that was during his opening statement where he indicated that there were over 60 grams. I don't know if he said fentanyl or I can't remember that, but I knew that he said there was over 60 grams. So if you just, my ruling is just that there were other baggages that were sent over that were not tested. So there's no, there's nothing presented to the jury of what they were.
Correct.
Okay?
Correct.
Just limited that.
All right, Your Honor, and I will grab investigator Lee.
Okay? And then when the investigator Lee gets seated, we can just bring the jurors back in. Frazier has made.
All right. So yeah, so they did a bench conference. They let the jury take a break because it was a long bench conference. But yeah, he tagged in his attorney. Anyways, Tupac, thank you so much for the 5 gifted memberships. That is awesome. Welcome to the 5 new members. Thank you so much, Tupac. I appreciate it. All right. Again, let's see what the attorney can do.
The decision to have Ms. McCarthy represent him at this time. Do not let his decision affect the way you view this evidence or decide the case. It's probably you prepared to go forward with cross-examination?
Yes, sir, I am.
Okay.
Yeah, legal patient. He just didn't know. His biggest problem is he didn't know how to phrase the questions he wanted to ask. If he was trying to get this officer to essentially admit to lying or catch him in a lie, he wasn't asking the questions the right way, and he was letting the officer answer beyond the scope of his question, which hurt him a lot. He didn't know to stop him. He didn't do a terrible job, but he definitely didn't help himself.
Good morning, Investigator Lee.
Good morning, ma'am.
I believe that Mr. Frazier was asking you about the confidentiality of the confidential informant. Did you set up the meeting with Mr. Frazier and the confidential informant?
Are you asking if I'm the one that directed the CS to? No, that was between them two. The location was determined between them.
Okay, did the confidential informant tell you where he was going to do it first?
I'm sorry?
Did the confidential informant tell you where he was going to suggest the meeting place was?
I believe, to the best of my recollection, the CS had already planned this prior to. This was something that was already going to occur until we made contact with the CS. And then he told us about the potential meet that day.
Okay, and is it proper to set up a meeting place at the confidential informant's family's home?
Again, the conversation was the CS had made the arrangement with Mr. Frazier prior to, without our direction, to be in that location at the residence.
Okay. And the reason that he wasn't documented is because you just met with him that morning?
Correct.
Is that normal procedure?
Is that normal procedure to not document?
Yes.
Or, again, unfortunately, that was not something that we intended to not document the CS. It just happened due to the time frame. It was about 3 hours until Mr. Frazier was about to arrive, and we set investigators in the area for the security of the CS's residence, if that makes sense.
Okay. Okay, thank you. I have no further questions.
Redirect.
Yes, Your Honor. Investigator Lee, I want to start with that last point. I want to talk a little bit about confidential informants and confidential sources.
Yes, sir.
Go into that a little bit more in depth. Confidential informant, is that somebody that is registered with your office and it provides information on an ongoing basis?
That's correct.
Sometimes you'll work operations and they'll provide information. Sometimes they'll do controlled buys for you.
Yes, that's correct.
Sometimes they're compensated for their work.
That is correct.
Now, how is that different from a confidential source?
That person doesn't have to be documented, and we can use the information to develop probable cause for a traffic stop or an arrest, things of that nature.
Confidential sources are just somebody who provides information to the sheriff's office and they don't want their name attached.
Correct.
Are you familiar with the Crime Stoppers program through the sheriff's office?
Yes,
Is that essentially what Crime Stoppers is?
essentially.
This particular case involved an individual that used as a confidential source.
That's correct.
He or she provided you information about Mr. Frazier.
That's correct.
Eventually, after all of this, well, let me ask you this. The information that was provided to you about Mr. Frazier, was that proved to be reliable information?
Yes.
Eventually, was that person signed up as a confidential informant?
No, they were not.
So all the questions and talk about following policy and confidential informants really doesn't apply to this particular individual at all, does it?
No, we did not use that individual again.
And the location for where this controlled buy, that's essentially what this operation was. It was a planned controlled buy, was it not?
Yes, sir.
The location of that was set by the confidential source, and law enforcement had no say into where this was going to occur, correct?
That is correct. I believe the source advised that prior to contact with us, that was a normal series of events between the CS and Mr. Frazier.
The document that Mr. Frazier showed you at some point, there was some conversation about 21 days, and I want to kind of go back through this and clarify things a little bit. So Mr. Frazier was arrested on scene for the drugs that are found on his person, correct?
That's correct.
And eventually, there was some discussion about some money that was found in his apartment.
Yes, sir.
He asked you about that.
Mhm.
After he was arrested, did you get a search warrant for his residence?
Yes.
So basically, after Mr. Frazier was arrested on July 26th, there was a search warrant that was granted for the defendant's apartment, correct?
Yes, sir.
And during that search warrant, you located a quantity of money.
Yes, sir.
And that document that Mr. Frazier was showing you and questioning you about was related to the forfeiture of the money that was found in his apartment.
That's correct.
Obviously, that money was found a couple days after he was arrested.
Yes, sir.
So this 21-day issue that the defendant tried to make a big deal of, in that document, what you're saying is within 21 days prior to searching his apartment, you found out information about him.
Correct.
You're not saying that you found out about him 21 days before, just somewhere within 3 weeks before.
That's correct.
And that's because for law enforcement.
I did not. I sat through the first maybe hour until he tagged his. Well, no, I wasn't even there when he tagged his attorney in. I had help getting this video because I couldn't sit through it for so long. It would have been a giant waste of my day to sit there for 3 hours to grab one clip. Because I court hop all day long. I cover maybe 50 courts a day. So I can't, just time-wise, I can't spend it all in one court. And so I actually had Lone Wolf grab this for me. I explained at the beginning of the video that the way that I grab clips and the way that he does it are two different ways. And yeah, he can do it easily with the longer clips. I can't do that the way I do it. So Lone Wolf grabbed this for me. So I have not seen pretty much from about 20 minutes ago until the sentencing. I did watch the sentencing.
Purpose is you can't get information, sit on it for 6 or 8 months, and then try to get a warrant based on stale information.
That's correct.
You got to demonstrate that the information you have is relatively current.
That's correct.
And that's where within the last 21 days comes in.
Yes, sir.
Mr. Frazier asked you some questions about the phone calls that were placed between the confidential source and himself. He asked you specifically, did he make any comments or any statements about delivering drugs? You remember him asking you those questions? Yes. You've worked in narcotics for almost a decade.
Right.
I guess how many times on occasion have you been involved in these types of phone calls between sources and drug suppliers?
Quite a few.
Would you say hundreds of times?
That's, yeah.
How often is it for the source of the controlled substances to specifically refer to whatever they're selling by its name, be it heroin, cocaine, methamphetamine, fentanyl? Is that common that they?
Objection, cause for speculation.
I'll rephrase, Sean. In your experience in dealing with these specific types of calls, how many, is it rare that they'll actually use the term for the controlled substance itself?
Yes, that's rare for them to identify whatever substance they are selling over a phone call, mainly because they're trying to avoid detection from law enforcement.
In your experience in dealing with these specific types of calls, is it more often than not that the conversations are had in some type of code?
Code or vague conversation, yes, sir.
Is it often that these types of conversations, when discussing what's to be delivered, is it that there's a discussion or the controlled substance is referred to by the amount that's being bought?
That's correct.
So if somebody orders 2 of something, in your experience dealing with these calls, what would that tell you?
Objection, speculation, yeah.
You may answer.
Depending on the type of supplier, 2 ounces, could be 2 pounds, just depending.
Depends on the drug.
The drug, yes, sir.
In this particular case, you listened to the phone calls that were placed.
That's correct.
And it was the code that you recognized that was being spoken.
Yes, again, I think I told Mr. Frazier without specifically reviewing it, I believe there was mention of 2 in somewhere in that conversation.
The last question I have for you is, Mr. Frazier asked you questions about the body camera policy at the sheriff's office.
Yes, sir.
So you are a narcotics investigator in the Special Investigations Division.
That's correct.
Are you currently issued body cameras in the Special Investigations Division?
Currently, we are now, yes.
When were you issued body cameras by the agency?
My recollection would have been after this, recently. I couldn't give you.
Would have been within the last 6 months, correct?
That sounds about right.
Back in July of 2023, you were not issued body cameras.
I don't believe we were.
Now, there are other divisions of the sheriff's office. There's the Criminal Investigations Division. They handle property crimes, violent crimes, things like that, correct?
Yes, sir.
Were they issued body cameras at that time?
I don't believe that criminal investigations was, not to my knowledge, anyway.
And there's what you consider the patrol deputies. They're the ones who, are out driving around, maybe doing speed enforcement, traffic stops, things like that.
Yeah, answering calls for service, traffic
Call
enforcement.
911, they're the ones who show up.
Yes, sir.
They have been issued body cameras for about 4 years now, correct?
That sounds about right.
So any body camera policy that the sheriff's office had when this incident occurred would have applied to those deputies who were issued body cameras, correct?
That's correct.
No further questions, John.
Mr. Clark, any other questions?
No, that's the job.
Can the witness be excused?
I'd ask that you remain under subpoena.
Sir, you're still under subpoena. If you'll leave the courtroom, however, you may be called back to testify.
Yes, sir. Thank you.
And you're still under the rules. You may call your next witness.
The State House Investigator Thomas LaRoche. And if I may approach the podium.
Yes, sir, you may.
With Darby, it is so good to see you. I want to personally apologize to you for the other night when I raided Irish Demon. I am so sorry. Not only was that the absolute worst time to raid Irish Demon, you were treated very rudely, and I apologize for that. I would ask you not to hold that against him and give him another chance when he actually goes back to not doing his drama streams, but it's up to you. But all I can do is ask. But I am sorry for how you were treated. I am currently 1-0. I beat Jen Hardy last week. I am playing People in Court this week, and I am currently winning. My running back put up 26 points on Thursday night, and she has Jared Allen, who only put up 8. So I am ahead 26-8 going into tomorrow, which is a nice bump to start the week. She's currently in first place. It's only been 1 week, so she's 1-0. I'm 1-0, but she destroyed last week. She scored 130 points, so yeah, she was the highest point scorer last week. So she's currently in first, but hopefully that bump from Thursday will help me win tomorrow.
Yeah, see. Question, you'll speak right into the microphone.
Yes, it was.
And,
Yes, it was.
you may inquire whenever you're ready.
Thank you, Your Honor. Good morning, sir.
Good morning.
Can you please introduce yourself to the jury?
My name is Investigator Thomas LaRoche. I work with the Bay County Sheriff's Office
How long have you been with the Bay County Sheriff's Office?
since 2019.
And what do you currently do with the Bay County Sheriff's Office?
I work for the Special Investigations Division.
That is the narcotics unit?
Yes, sir.
How long have you been in the narcotics unit?
Since January of 23.
I want to take you to July of 2023, July 26th. Were you involved in the investigation into Jamie Frazier?
I was.
What was your involvement in that?
I was involved with the traffic stop mentioned in the report.
What did you do with that traffic stop?
I helped detain and search Mr. Frazier.
When you say you search this person?
Yes, sir.
May I approach, Your Honor?
You may approach.
Showing it's been pre-marked for identification states 1A, B, and C. Take a look at those 2 photographs for me, please.
Yes, sir.
Do those photographs accurately depict what you found when you searched Mr. Frazier's person?
That's correct.
All right, this time the state would move states exhibit 1A, 1B, and 1C to the evidence.
Any objection?
No, Your Honor.
Phase 1A, B, and C will be accepted evidence. You may publish whenever you're ready.
Madam Clerk, if I could please have the screens. Let's get a large. What are we looking at here in states 1A?
That would be Mr. Frazier.
Specifically, is there anything that stands out about this?
There's a abnormal bulge in his pants.
And that's in his growing area?
Yes, sir.
Was that area searched?
Yes, sir.
1B, what are we looking at here?
1B, you're looking at what was found in his crotch area.
These were the items that created that bulge in 1A.
Correct.
And it looks like we've got 2 clear baggies with 2 red packages.
That's correct.
And then 1C, what are we looking at here?
Those were the opened red packages.
So there were clear baggies inside of those red packages.
Correct.
Now, all of these items were ultimately collected.
That's correct.
I have one more, please, Sean. After items were collected, were they ultimately sent to the Florida Department of Law Enforcement?
I believe so, yes.
May I approach, Sean?
May approach.
Showing you what's been pre-marked for identification in State's Exhibit 2. And I'm going to show you 3, 4, and 5. Take a look at those items for me, please.
Okay.
Are those the substances in these photographs that were taken from Mr. Frazier's growing area?
That is correct.
It's time to say move State's Exhibit 2, 3, 4, and 5 into evidence.
Any objection?
Yes, Your Honor. We object until FDLE comes here. We don't have any evidence about what did.
Not introducing it as anything at this point in time, just that there was substances found on Mr. Frazier's body. Mr. Corcoran?
If it's for that purpose, we don't object.
They'll be accepted into evidence, and you may publish whenever you're ready.
Thank you, Your Honor. I've got no further questions for this witness, Your Honor.
Mr. Corcoran?
morning.
Good morning.
Investigator LaRoche, were you the person that sent the substances to FDLE?
I was not.
Who was? Do you know?
It'd be the case agent, Investigator Lee.
Okay. And did you give them to Investigator Lee?
On scene, yes, ma'am.
Okay. What made you search Mr. Frazier in his groin area?
The abnormal bulge.
Okay. Is that something you normally do?
If abnormal bulge is present, yes, ma'am.
Okay. But the pictures that were shown, his pants are buckled and pulled up. So how did you search him?
I had to open his pants.
And then you close them back up?
I don't remember. I believe so. He was handcuffed. I must have.
Okay. Is there any reason why you didn't take any pictures of him unbuckling his pants?
I believe Mr. Frazier was not being very compliant at the time.
I can't. Oh man, this line of question. I haven't seen this part of the video, and this is hilarious. How does nobody? I mean, this is a very serious matter. Of course, they're not laughing, but this is hilarious. Just the innuendos. Man, you guys are killing it with the comments too.
And that would keep you from taking a picture?
When we're trying to restrain him, yes, ma'am.
Okay. Did you have body cam on?
No, ma'am.
Did anybody have it?
I don't recall.
Okay.
I know I wasn't.
You know you didn't?
Yes, ma'am.
Okay. Okay. Who else was there?
I don't recall. I remember myself, Investigator Lee, I believe Sergeant Head. I can't recall who else off the top of my head. I'm sure a couple other members of SID.
Okay. And were you all at the surveillance part of it before you stopped Mr. Frazier
We were all spread out in the general area.
in vehicles?
Yes, ma'am.
Okay, so who was the one that approached Mr. Frazier first?
I don't recall off the top of my head.
Okay. Did someone took pictures of all that though, right?
I'm assuming.
Trafficking. I don't remember exactly what the charge is, but it's something to do with drug trafficking because of how much he had. He had 60 grams of fentanyl on him. He also had other drugs that weren't tested, so they're not allowed to bring that up in the trial. They brought that up earlier, but 60 grams of fentanyl. He's looking at a minimum of 25 years in jail.
So I don't have them in front of me to say for certain.
Okay, were you the person that took the pictures?
No, ma'am.
Okay, thank you. No further questions.
Any other questions?
No, Your Honor.
The witness be excused.
Yes, Your Honor.
All right. Sir, you may go about your day.
Thank you, sir.
Your Honor, we have him under subpoena.
Okay, sir, you're still under subpoena. If you'll go back and you're still under the rule until you're called to court.
Thank you, sir.
I'm Officer Colin here. I may approach the witness stand, Your Honor.
You may approach.
And you should just stand up here by the chair, please, and tell the clerk where it's in.
Do you solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
May inquire.
Morning, ma'am.
Good morning.
Can you please introduce yourself to the jury?
My name is Pallavi Vera.
Ms. Vera, where are you employed?
I'm employed with the Florida Department of Law Enforcement.
What do you do with the Florida Department of Law Enforcement?
I'm a crime laboratory analyst in the seized drugs section.
How long have you worked in the seized drugs section of the Florida Department of Law Enforcement?
Approximately 20, 24 years, and in this capacity, approximately 10 years.
And what, as a crime laboratory analyst, what do you do for FDLE?
As a crime laboratory analyst, I analyze items of evidence for the presence or absence of controlled substances and write a report on my findings.
And you said you've done that particular job for FDLE for 12 years?
Approximately 10 years.
10 years, I apologize.
Yep.
And in those 10 years, how many times would you say that you've been provided a substance to determine what that substance is?
Over 10,000 times.
Over 10,000 times. Have you had occasion to determine whether a substance is fentanyl or not?
Yes.
Can you estimate about how many times you've analyzed a substance to determine whether it's fentanyl?
Over 1,000 times.
Can you explain to the jury what type of training, education, and experience that you have that allows you to do that job?
I have a Bachelor of Science degree in biochemistry and Master of Science degree in life sciences. As a crime laboratory analyst, I underwent an intense training program. It lasted approximately 11 months. It included academics, practical exercises, and supervised casework.
As part of your job with FDLE, do you undergo what's called proficiency testing?
Yes.
Can you explain to the jury what proficiency testing is and also tell them how often you undergo that?
Proficiency testing is a test that we get from the outside agency or from the internal, from our department once a year. And it's unknown to us, and we analyze that just like we would analyze a case sample.
And you're tested for your accuracy in analyzing that specific substance, correct?
Correct. It tests for the techniques that we use as well as our efficiency to do that.
And how often do you undergo that testing?
Once a year.
FDLE is an accredited crime laboratory, correct?
Yes.
And that's partly why you have to undergo this proficiency testing.
Correct.
There are standards and requirements that you must meet.
Correct.
Have you had occasion to testify as an expert witness in court previously?
Yes.
How many times?
Over 120 times.
This time the state would tender the witness for voir dire.
Any questions?
No, Your Honor.
I ask that she be permitted to render an opinion.
She may be able to testify and give her opinion.
Ms. Vera, I want you to, let me first ask, you were asked to analyze substance in this case, correct?
Correct.
Could you explain to the jury how that process goes from when you receive the substance to what you do?
So once it comes into the laboratory, it is given a specific FDLE number, and then it comes to me. It is assigned to me by my supervisor. Once I receive the evidence, I open the evidence, look at the evidence, and take detailed notes on what is the inner and outer container is, and what is the inside substances. And then I would take a small amount and do a chemical color test as well as 2 instrumental tests.
What are those instrumental tests?
One is called gas chromatograph, and another one is called gas chromatograph mass spectrometer.
And what is the purpose of doing the color test and the 2 instrumental analyses?
Color test kind of gives us it's a preliminary test. It gives us an idea what type of substance could be present. Instrumental tests are where gas chromatograph mass spectrometer is a specific test. So whenever the sample is introduced into the instrument, it breaks down into small pieces. The chemical breaks down into small pieces and then produces a fragmentation pattern. And this pattern looks like a bar graph, and it is compared to a then known standard. So it's a specific test. It's every time you would put that substance into the instrument, it would exactly produce the similar pattern, and then you can compare that to a standard. Gas chromatograph is another instrument which we do to confirm our presence of certain substance that we have found in mass spectrometer, and then we confirm that by using gas chromatograph.
So these tests and the instrumental analyses they do, they're able to allow you to scientifically determine what a substance is.
Correct.
Were you asked to do that in this particular case?
Yes.
Approach, Your Honor.
May I approach?
I'm showing you what's been admitted evidence, State's Exhibit 2. If you could take a look at that for me, please. Do you recognize that?
Yes.
Was this one of these substances that you were asked to analyze?
Yes.
And you performed those tests and analyses that you described on that substance?
Yes.
Bruce, we are at 1 hour and 13 minutes into the video, and this is an hour and 48 minutes long. So, quick math, 48 minus 13, what is that? 35 more minutes? No, pending my pauses, probably about 45 more minutes, I would say, of this video.
And based on your analysis, were you able to scientifically determine what that substance is?
Yes.
And what were you able to determine?
It contains fentanyl.
And as part of your duties and responsibilities, do you determine the weight of the substance as well?
Yes.
Were you able to determine the weight of the fentanyl in this particular case?
Yes.
Can you explain to the jury how you determine the weight?
So once I open the evidence and I take the substance out of the container or the bag, and then I place a plain paper onto the balance, I tear the balance to 0, and then I put the substance onto the balance and record the weight.
And in this particular case, in that exhibit, there's a plastic baggie and then there's a red baggie as well.
Yes.
And that's how the substance was packaged when it came to you.
Yes.
When you weighed the substance, did you weigh it inside of those packaging or just the substance itself?
Just the substance itself.
And were you able to determine the weight of the fentanyl in this case?
Yes.
What was the weight of the fentanyl in this case?
Weight is 28.355 grams.
Now, this particular exhibit, was that the only exhibit that was submitted to you from the Bay County Sheriff's Office for analysis?
There was another item that was submitted also.
I approach, Your Honor.
May I approach?
I'm showing you what's been admitted in evidence as State's Exhibit 4. Was this also submitted to you for analysis?
Yes.
Did you ultimately conduct an analysis on that particular exhibit?
I did not.
Why not?
Per our protocol, we analyzed the best item to substantiate the highest charge, and in this case, it was accomplished.
So I want to talk about that a little bit. So in this particular case, we're talking about fentanyl, and there are several different thresholds for trafficking in fentanyl, correct?
Correct.
4 grams, 14 grams, and 28 grams.
Correct.
And when you analyzed that first exhibit that you talked about, you reached the highest level possible.
Yes.
So your policies say not to analyze anything else.
Yes. So the highest threshold was met in this case. That's why the analysis was ceased.
Let's say, for an example, that the exhibit that you did analyze came back as 27.9 grams, just under that 28 threshold. Would you have then continued to analyze the second substance as well?
Yes.
But because you've already reached that highest threshold, there is no need to continue.
Correct.
We got no further questions, John.
Good morning.
Good morning.
When you analyzed the substance that you did analyze, how much of it did you analyze?
We take normally 1 milligram per milliliter.
A milligram or a milliliter? So in this case, it would have been a milligram?
Yes.
Okay. So how do you know that the rest of it is the same substance?
The substance that we take, we look at it and we take the random sample from the substance.
Right. But how do you know that the rest of it is also the same substance?
It is a substance where we take the random sample from it. So I have no way to know whether it's a mixture or it's not. in my case, I received just one substance in there, controlled substance.
But you assumed it was 28 grams.
Correct.
Okay, thank you. No further questions.
Yes, Sean. Ms. Vera, you mentioned the term mixture there. Under Florida law, a mixture of substances qualifies as that substance.
Correct.
So, for example, if I take 4 grams of sugar and mix it with 4 grams of flour, and you test it, and I mix it all together, that under Florida law qualifies as 8 grams of sugar or 8 grams of flour.
Correct.
So when you take a representative sample, you only have to take a small amount because under Florida law, the whole thing, the whole mixture is considered that particular substance.
Correct.
No further question, John.
You have a question for this witness?
No.
Can she be excused?
Yes, Sean.
Yes, Your Honor.
Ma'am, you may go about your day.
Thank you.
Some you can call your next witness.
All right, it's time to sit rest.
Ladies and gentlemen, this is appropriate time to take our second morning break. We're going to take a 15-minute break. We'll start back at 5:11. Remember to leave your notepads in the courtroom. Do not discuss the case among yourself or with anyone else. Don't use your electronic devices to find out any more about the case you know right now. Don't check any media sources to find out any more about the case. You'll call the bailiff in the back.
Oh no, did I not skip this part?
But he, when I talked to Detective Roach, he just, for the first point, the substance has not really been connected to Mr. Frazier. The pictures don't show that Mr. Frazier ever had possession of it. There was testimony, but he, when I talked to Detective Roach, he just said that he was very uncooperative, and that's why they couldn't get any pictures with him with the drug. The second basis for the motion for judgment of acquittal is that the state has not presented sufficient evidence that Mr. Frazier possessed this substance, and that Mr. Frazier knew that it was present and that he had control over it.
Over.
Your Honor, the testimony is that the drugs are found in his growing area. That's more than enough to prove that preliminary basis.
I'm going to deny the judgment of acquittal at this time. And see, Ms. McCarthy, you're intending on calling witnesses, is that correct?
Yes, sir.
Has Mr. Frazier made a decision whether to testify or not?
He hasn't decided yet.
Okay, let's go ahead and take our break. And Mr. Frazier, if you'll need to take a break, they'll take you back in the back. Okay, well, that's up to you. I mean, and then we'll, after we take a break, before we bring the jurors back in, if he's made a decision, we'll go through that colloquy, okay? And we can go into recess for 15 minutes. Ms. McCarthy, you may call your first witness.
We would recall Trevor Lee.
Okay.
I can go.
We'll go get him, please.
Oh, that would be hilarious. If she stepped down the hall to go get the witness and then she just never came back.
Stand.
After this entire big bulge comment section, I don't know if I could have taken any more if she would have done that. Yeah, that's not professional at all. She never would have done that, but that I would have laughed. I would have laughed real hard.
And sir, you're still under oath. Ms. McCarthy, you may inquire whenever you're ready.
Thank you, Your Honor. Investigator Lee, we had asked you several questions when you were on the stand before. Do you remember talking to Mr. Sullivan about CIs and CSs?
Yes.
Okay. Wasn't this particular person a CI because he'd made a controlled buy?
It was not a controlled purchase, something more similar to what we call a buy bust. We contact the supplier. They arrive to an agreed upon meeting location. Prior to them getting or passing on said narcotics to the CS or CI, we obtain probable cause to take them into custody so that they don't make contact with the CI or CS.
Okay. And you said that there was a telephone call and that Mr. Frazier spoke in code?
Yes, ma'am. I did have a chance to review that during the break, and yes, ma'am.
What did he say?
I believe in the conversation, there was discussion of food. If he was getting something to eat, he said yes. Agreed upon meeting at the location at 3, and the conversation, the agreed amount was a couple, which was different from what I said earlier, but that was my mistake. I didn't review the phone call prior to today.
But Mr. Frazier didn't say a couple, did he?
Nope, that's correct. But he agreed upon bringing a couple based on the phone call. Yes, ma'am.
He asked him what he meant,
Correct.
and then he said it again.
And then he said a couple.
Yeah, I'll meet you.
Right. And then arrived at the meeting location with a couple ounces of fentanyl. Yes, ma'am.
Okay. Did you take the pictures of the substances?
I do not recall who took the pictures. It may have been me, whoever was on scene. There were several of us there.
Okay. Who is there besides you and Investigator LaRoche?
That's Sergeant Head, Lieutenant Higgins. I believe there was a few other investigators present as well. I can't quite recall, but I'm sure it was several of us there.
Okay. And Investigator LaRoche was the one that searched Mr. Frazier?
That's correct.
Okay, but you don't know who took the pictures?
I don't recall.
Okay. May I have one moment, Your Honor?
Now, I do want to remind you guys that she didn't get to question this witness because the defendant was still pro se when this witness was on the bench, on the witness stand. So this is her first time question. And you notice that she's not going at him about lying, which is what his whole premise was.
Investigator Lee, would it refresh your memory to hear the phone call again?
I just heard it during the break.
I'm sorry?
I just reviewed it during the break.
Okay. Mr. Frazier didn't agree to anything, did he?
He agreed to arriving at 3 o'clock at the CS's residence. And when the CS advised a couple, and that was pretty much the end of the phone call, I'll be there.
But he didn't say anything else.
Based on my training experience, if he's traveling to a CS's location or CI's location for that matter, it's probably to conduct a narcotics transaction.
But it really could have been anything.
Well, he was found with 2 ounces of narcotics in his pants, so I don't think it could have been anything at that time.
But before the narcotics were found or allegedly found, he could have meant anything. He didn't say anything about drugs, did he?
That's 100%. The conversation, as I said in the call, it says talking about food. You have anything? Are you getting something to eat? Dog food is a street term for heroin or fentanyl.
He didn't say dog food though. He just said
No, he did not. I'm based on my experience when he's talking about something to eat. That's a terminology they use when they're talking about dog food, which is a street term for fentanyl or heroin.
But he never said dog food.
No, I'm not saying that he said dog food. I'm telling you what I interpreted based upon the phone call.
Okay. I have no further questions. Thank you.
Mr. Sullivan?
Investigator Lee.
Yes, sir.
During that phone call, there was an agreement between Mr. Frazier and a confidential source to show up at a location at 3 o'clock.
Correct.
Mr. Frazier showed up at that location at 3 o'clock.
That's correct.
When he showed up at that location at 3 o'clock, he had a quantity of fentanyl on it.
That's correct.
Does it matter what he said on that phone call?
No, it does not.
He could have said that Martians were invading the planet, but when he showed up at that location, he had fentanyl on him.
That's correct.
No further questions.
Are you there for this witness? Anything else for this witness?
May I have a moment, Your Honor? Thank you. Yeah.
Anything else?
Okay, nothing else, Your Honor.
Can the witness be excused?
Yes, Your Honor.
Or you can go about your day. Thank you. Call your next witness.
Investigator LaRoche.
Okay. Sir? No, sir. Listen to me. You're not gonna sit there and mumble under your breath in this trial. I'm gonna admonish you to be quiet, okay? And that's your first admonishment.
Anyone catch what he said? I didn't even hear him. Judge Clark has those ears. I thought with that head of hair, maybe it was covering his ears, but nope. Minimum is 25 years. 25 years minimum. Your guys' favorite witness is back.
I would, if you'll testify and speak to that microphone, Ms. McCarthy, you may inquire.
Thank you, Your Honor. Investigator LaRoche, when you searched Mr. Frazier, were there other officers around?
I believe so.
Okay, and they were one of them was taking pictures.
I believe so, but I don't remember who.
Great. And did one of the officers have a body cam on?
Like I said earlier, I'm not sure. I can just testify that I didn't.
Right, you didn't. If I showed you a picture, would you refresh your recollection?
Possibly.
Okay. May I approach, Your Honor?
You may approach.
I'm showing you what's been previously marked as a defense exhibit 3. And I'm showing you the corner.
Am I right here?
Yes.
Yes, ma'am. That's a handcuff.
I don't remember. I think I covered one of his videos. I'd have to go back and watch, but I remember. I don't know. Maybe pleading to they would have taken off the trafficking charge and just pled to a high level of possession. I feel like there's a habitual offender on this case as well. That's why the minimum is so high. Because I don't think trafficking alone is 25 years. I feel like there has to be some more. There has to be something else to make it, or maybe it is. I'm not sure, but yeah, it would have been way less than 25. It might have been 10.
Pouch.
That's not a.
No, ma'am. That's a handcuff pouch.
Okay. And do you know who that belonged to?
That was mine.
Okay.
That is a lot of fentanyl, though. It's a lot of fentanyl.
May I have a moment, Your Honor?
2 ounces is not a lot. It's a small amount of weight, but when it comes to fentanyl, that's a lot. So 60 grams of fentanyl is a lot of fentanyl. It's enough to be a trafficking charge. And I have now said fentanyl so many times that there is no way that this video is going to be monetized. Of course.
Investigator LaRoche, why is it that you all took pictures of the drugs before you took pictures?
Yes, it was 60 grams, and which was, what did they say? It was like 2 point. I don't remember the actual decimal number of ounces.
Pictures of Mr. Frazier.
I'm not sure. I'm not the one who took the pictures.
Okay.
Oh, am I doing my math wrong? Yeah, they said 60 grams at the start, and then they kept saying it was 2 point some ounces. So if I'm doing my math, I'm just reading. I'm just following what they're saying. So I didn't do the math actually. So I didn't do it wrong, but it was 2 point something ounces, and yeah, they said 60 grams.
Isn't that kind of unusual?
It's not very usual that drugs are hidden in the crotch area. I mean,
Okay, would it refresh your recollection to show you the pictures?
is it the same ones that you just showed me?
No, it's another one.
Maybe.
Okay.
You may approach.
This is a picture that we were provided.
Yes, ma'am.
What are those in the bags?
May I look at them?
Sure, sure.
I mean, I can't testify to what they were. I can just testify what I suspected them to be.
Okay, you're the one that searched, so what did
Correct.
you suspect them to be?
Illegal narcotics.
Okay, and is there some reason, like I asked you before, why those pictures would be taken before Mr. Frazier would be taken?
Objection asked and answered.
I'll overrule the objection. He can answer the question after he looked at the,
Can you
picture.
restate your question?
Is there some reason why you would take pictures of the drugs before you took pictures of Mr. Frazier?
I'm not the one who took the pictures, so I don't know why they weren't taken before or after.
Okay, thank you. No further questions.
Any other questions from this witness?
No, Your
Mr.
Honor.
Sullivan?
No, Your Honor.
Can he be excused?
Yes, Your Honor.
Mr. McCarthy?
Yes.
Sir, you may go about your day.
Thank you, sir.
Ms. McCarthy, you can call your next witness.
I'm gonna call Sergeant Head.
Okay.
I'll get him.
Yeah, she is trying, but she started way behind. Having the defendant pro se at the start with that
Stand
first
by the
witness.
chair, please, until the clerk swears in.
Yes, sir.
You solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Sir Jeff, you have a seat speaking to the microphone. Ms. McCarthy, you may inquire whenever you're ready.
Okay, please state your name for the record.
Jeremy Head,
And where do you work?
the Bay County Sheriff's Office.
How long have you worked there?
About 14 years.
Okay, and are you familiar with this particular transaction with Mr. Frazier?
Yes, ma'am.
Were you involved in it?
Yes.
Were you the supervisor?
I was one of them.
There was more than one supervisor?
Yeah, Lieutenant Higgins was there as well.
Okay. Did you know that the confidential source was not documented?
I didn't deal with that part of the investigation.
But you were supervising Investigator Lee, right?
Lieutenant Higgins was with him at that time.
Okay, what did you do in the investigation?
Well, Investigator Lee said that an individual would be showing up to a particular place, meaning Bonnie Girls Way, around 3 o'clock on that date. The individual didn't have a driver's license and suspected to be bringing narcotics. So I set up in the area to assist him.
Okay, and did you assist in arresting him?
Yes, ma'am. I set up, when Investigator Lee relayed that Mr. Frazier was coming into the area, I went down, Bonnie Girls Way is like a single lane dirt road. I went down there to get eyes on the individual, which I did, Mr. Frazier and the vehicle he was driving. And I surveilled that vehicle until it left, and Investigator Lee and us came up with the decision to stop the vehicle at the stop sign at the intersection of Bonnie Girls and Spikes Road.
Okay, and what's a pin stop?
Pin stop is simply where one vehicle's in front of the car and one vehicle's behind the car to prevent any possibility of fleeing.
Okay, so that keeps him in.
Yes.
Okay, and did you do that in this case?
Yes, ma'am. I was the back vehicle. I initiated the traffic stop.
May I have a moment, Your Honor?
Yes.
Thank you, Sergeant Head. I have no further questions.
Any questions, Mr. Sullivan?
Yes, Your Honor. You were asked about the confidential source in this case being documented.
Yes,
Is it routine that the sheriff's office receives information from members of the public?
all the time.
Is everybody who provides information signed up as a confidential informant?
We can't force people to be signed up and, people call in, citizens, and not everybody.
So it's routine that you use information from individuals and they don't get signed up.
Correct.
So the fact that this particular confidential source was never used as an informant, that doesn't surprise you or raise any red flags with you?
No, there's, like I said, there's a variety of reasons for information being given. Over the years, there's any number of reasons.
And you told Ms. McCarthy a moment ago that you relayed information that this particular individual didn't have a driver's license.
Yes, sir.
Did you yourself see Mr. Frazier driving that vehicle prior to conducting the traffic stop?
Yes, sir, I did.
No further questions, John.
You redirect?
Yes, sir. Sergeant, you said that it's normal for people from the public to help you with cases.
Absolutely.
And is it normal to have them set up calls with the target?
Like I said, there's, over the years, I've seen any number of variations of people giving information and any variation of, how much they help. So
Okay.
I really can't say what's normal and what's not when it comes to that.
Okay. But it is your policy with confidential informants to have them registered. Is that correct?
There is policy in place about confidential informants and registry is part of it.
And it's 4322.0?
I can't quote it off my mind, but I'll take your word for it.
Okay. Thank you. No further questions.
Any other questions?
No, Your Honor.
Sergeant, Ms. McCarthy, can you be excused?
Yes, sir.
Sir, you may go about your day.
Yes, sir. Thank you, Your Honor.
Yes, sir. Ms. McCarthy, you call your next witness.
I would call Lieutenant Higgins.
Yeah, I think that's what they were trying to differentiate between a confidential source and a confidential informant.
This way, sir. Make sure you stand by the chair so the clerk's ready to answer.
You solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Ms. McCarthy, you may inquire.
Thank you, Your Honor. Good morning.
Morning.
Please state your name for the record.
Yeah, it does seem like this is dragging on, but it's a jury trial and it only lasted 3 hours, and that's with 3 different pretty long breaks. There was an hour-long lunch break in there too. So yeah, I think this is pretty short for a jury trial, is what I'm saying.
It's David Higgins
And where do you work?
at the Bay County Sheriff's Office.
And how long have you worked there?
Almost 23 years.
Okay. And do you recall on July 26th, a transaction with Mr. Frazier?
I do.
Okay. What was your role in the investigation?
I was one of the supervisors on scene at the search warrant, and then was part of the takedown team.
Okay. There wasn't a search warrant though, was there?
What are you talking about?
There was no search warrant in this case, was there?
You talking about before this all started?
Right.
Yes.
There was a search warrant?
Mhm.
And where was it?
At an address on Bonnie Girls Way?
Okay. Oh, but not for Mr. Frazier.
No.
Oh, okay. So the person that was used as a CI had already had a search done to his home?
Mhm. Yes.
Oh, okay. Okay. Do you know if the person, the CI, was documented?
At that moment, I couldn't tell you if they were or not, because it happened so fluid and fast.
Okay, should they have been?
It depends on the time frame. If we are at somewhere and we're being told that a person is coming with narcotics, then we have to transition to a takedown. And so you didn't have time to do all the necessary stuff you would do to document a CI.
Okay, but the sheriff's policy is to document them, right?
When we have had time, we would have, but in that case, it happened so fast and fluid that that wasn't a thing. It couldn't be done in time.
Okay. May I have a moment, Your Honor? One more question.
Yeah, I already felt kind of bad saying that it was a pro se jury trial because, it was only pro se for the first, 25% of the trial. So I didn't want to really add anything into it. Also, I didn't see this far into this case. So I didn't know that there was a battle of the bulge. Did not know that. But yeah, I would change that. You know what? I should probably change that now. I might change that after it's finished. That's a good idea.
Lieutenant Higgins.
No problem.
The CI that we were talking about, he wasn't just a member of the public, was he? He wasn't just someone that came off the street with some information, was he?
He had information for us when we arrived at the location.
And he was in trouble.
Yes, you could say he would have been in trouble.
Okay, thank you. No further questions.
Any questions?
You were asked about documenting confidential informants. This was a good example of you were provided information that a source of supply was showing up in a quick amount of time and you had to transition to a takedown posture. Right?
That's correct.
But that policy of documenting individuals, that applies to confidential informants, correct?
Correct.
People that you use on a regular or a routine basis, or at least multiple times, correct?
Correct.
And in this particular case, this particular individual provided you information on this one day and wasn't used again after that, correct?
Correct.
So the policy of documenting confidential informants wouldn't have even applied to this individual, whether you had time to document them or not, correct?
The source gave us information that was happening right then, and yes, that is correct.
And how long have you been with the sheriff's office?
Almost 23 years.
And in those 23 years, is it routine for individuals to provide information to the sheriff's office, but yet not be a registered confidential informant?
All the time.
That's exactly what the Crime Stoppers program is designed for, correct?
Correct.
No further questions, John.
Any other questions for this witness?
Yes, sir. So Lieutenant Higgins, this particular confidential source was working off a charge, right?
We were in the process of the event that was taking place, the search warrant.
Mhm.
Your client was already on his way. And we transitioned directly into waiting for him to arrive on scene.
But that was so that he wouldn't get charges. So the confidential source wouldn't get charges.
I mean, he told us what was happening. He said, look, he's on his way.
And that was to help you?
That was to help us?
Yes.
Yes.
Okay. So he needed to be documented then, right?
No, not at that point.
Thank you. No further question.
Anything else for this witness?
No, sir.
Any issues?
No, sure.
Sir, you may go about your day.
Thank you.
Call your next witness. You can call your next witness.
At this time, we're at the restaurant.
Okay.
Oh, I'm sorry. Yeah, no. I'm gonna call Mr. Frazier.
I just thought I made a big mistake. When she said this time they're going to arrest, I'm like, wait a second. No, I know the defendant testifies. This is one of the best parts of the trial. At least I hope so. I skimmed through it, but yeah, not a good idea, man. Not a good idea. But yep, let's go.
You solemnly swear or affirm the testimony about you to be the truth, the whole truth, and nothing but the truth, so help you God.
You have a seat, speaking to the microphone. Ms. McCarthy, you may inquire.
Thank you, Your Honor. Please state your name for the record.
Jamie Laquan Frazier.
And Mr. Frazier, You've sat through all this, right?
Yes,
Okay. Have you ever been convicted of a felony before?
yes, I've been convicted of 4 felonies.
4 felonies? Okay.
Yes.
This case, you were stopped when you had gone to somebody's house, right?
Yes, ma'am.
Did you agree to bring drugs to that house?
No, ma'am.
Okay. Did you have any drugs with you when you got there?
Marijuana.
You had marijuana with you when you got there?
Yes, ma'am.
Did you have anything else?
That's all I had.
Okay. And were you just going to meet the confidential informant?
I was going to take marijuana. That's all I would take with the picture show. They don't, they're not showing those pictures at trial. They just showing something else that wasn't pertaining to me.
It wasn't pertaining to you.
What they say they found was not pertaining to me. They're not showing the actual picture that they showed with the marijuana right there.
Non-responsive. Same, answer the question.
Was the fentanyl, was it yours?
No, ma'am.
Did you bring any fentanyl there?
No, ma'am.
Okay, you just brought marijuana.
Yes, ma'am.
Okay, thank you. No further questions.
Subject questions?
Your testimony is that this is one giant conspiracy against you.
Yes, sir.
You heard the testimony from Investigator Lee. He didn't know who you were prior to that day, correct?
Oh, yes, sir. I heard that testimony.
And yet he conspired to plant 30 grams of fentanyl on you for no reason whatsoever.
I don't know what's the reason, but that's what he did. I'm not saying he did. Hold up, let me take that back.
Well, yeah, I mean, you're answering my question, Mr. Frazier.
No, I didn't. No, I didn't answer the correct. Investigator Lee wasn't the one who came up on me.
Okay,
And
so
showed me the drugs soon as he got out the truck, the dude with the long hair.
and that brings me to my next question, Mr. Frazier. So not only is Investigator Lee lying about all this, your testimony today is that Investigator LaRoche is also lying.
Yes, all of them are lying.
They're all lying.
Yes, LaRoche the one got out the truck with the drugs.
All of these officers are lying, but yet you're the 4-time convicted felon.
Well, that has to do with it. It has been proven that cops lie.
No further questions, Your Honor.
All right, any other questions?
Nothing further, Your
I
Honor.
can call your next witness.
Now the defense would rest.
All right, Mr. Sullivan, any rebuttal?
No, Your Honor.
Ladies and gentlemen, we're gonna take a short break. I know it's around lunchtime. I understand the jurors have reached a verdict. Is that correct? Yes, sir. Mr. Clark, if you'll hand the,
All right. I know this goes straight to verdict. The closing arguments were not in the video that I received. I don't know if it happened off YouTube because the video did end. And then there's a second video with the verdict. And because of the lunch break, I feel like that they started here and we didn't get to see the closing arguments. So that is not my fault. I don't think that's Lone Wolf's fault either because he sent me the raw court footage. So I really think that they did the closing arguments off of YouTube. So I do apologize for that. It's not my fault, but we do get the verdict. Here we go.
verdict, Deputy Dexter. All right. Ms. McCarthy and Mr. Frazier, if you'll both rise.
Circuit Court, 14th Judicial Circuit of the State of Florida in and for Bay County. State of Florida versus Jamie Laquan Frazier. Case number 2023 CF 2845. Verdict. We, the jury, find as to the defendant, Jamie Laquan Frazier, as follows. Count 1. The defendant is guilty as charged of trafficking in fentanyl. Special findings. If you find the defendant guilty of trafficking in fentanyl, you must further choose one of the following. The fentanyl weighed 28 grams or more. So say we all dated this 4th day of September, 2024. Foreperson, Herbert Clark.
We'll have a seat. Madam Clerk, if you'll poll the jury, please.
Yes, sir. Ms. Bowling, is this your verdict?
Yes.
All right, I'm going to fast forward the polling. I should have taken this out because they say their names and I don't want their names on here. So just a heads up. Hopefully.
About your deliberations. You are also at liberty.
14th Judicial Circuit of the State of Florida in and for Bay County.
Yeah, it must be really quick. I still don't want their names on here. Let's see, 4658.
Fentanyl. Special findings.
Sorry, Trying.
And Mr. Gaynor, is this your verdict? Thank you.
Ladies and gentlemen, I wish to thank you for your time and consideration in this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that the jury's deliberations, discussions.
I think that's different state by state because sometimes they ask. The judge will say, "Do you want us to poll the jury?" So I feel like that's an option in some states. In Florida, it must be required because it wasn't given as an option. Also, I want to bring up. I talk about Bruno. I'm so sorry that I didn't shout you out. I do apologize. I remember reading it off and waiting until the next pause to call you out, and I did not. So I apologize. Thank you so much for the super chat. I think abnormally large bulge gets you demonetized. It might. I don't know. We'll see. We'll see what happens. But I really don't think this video is going to be monetized. But we had a great turnout. There's 250 you guys, so this is awesome. We still have 5 minutes left. I'll pause it one more time to say bye. But it is 4 o'clock. We might have someone that we can raid. I'll go look to see who we can raid. But video's almost over. So I'm going to let this video play until the end. And I'm going to pause it one more time to say bye.
And votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you're at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss your verdict or your deliberations may come from those who are simply curious, from those who might simply find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. Ladies and gentlemen, thank you for your service. Our system of justice will come to a grinding halt without citizens such as yourself taking time away from your daily activities to come and serve as jurors. This is what separates our country from the rest of the world. We don't have judges sitting up here, a panel of 3 judges making these decisions. We have citizens, private citizens that come in here, consider the evidence, and make a decision. With that being said, thank you for your service. You are discharged. Make sure you have all your personal belongings. If you'll leave your notepad, we'll destroy your notes. If you'll call the Benton County Sheriff's Office, they'll escort you to the apartment.
Hey, Bill, just step this way, get behind that, which out of the building, we'll unlock the lounge for you getting property left in there.
Man, I really failed at the end of this video. Trying to make sure the jurors aren't there. All right, I think we're good. So, Wixom, I saw you asked about the sentencing. The sentencing is right now. You know what? There's 3 minutes left of this video. I'm just going to peace out now. Thank you guys so much for watching. I know this was a long video. Thank you so much for hanging out with me today. You guys are awesome. Thank you guys for the super chats and the membership milestones, gifted memberships. You guys are truly awesome. You are the reason why I keep doing this, so I do appreciate it. And Meg's Crime Watch is live right now, so let's go say hi to her. So that's who I have set to raid. But I am taking the night off. It is Saturday night, so I do take Saturday nights off to spend with Heather. Legal Fiction, thank you so much for the 8 months. We got these milestones coming in. Perfect timing, though, so I don't have to pause it again. Legal Fiction, I appreciate it, man. Thank you so much for the 8 months. And thank you so much for being a mod. I appreciate it, Legal Fiction. Colin, thank you so much for the 2 months. You are awesome. You are awesome. Don't tell Legal Fiction, but you're more awesome than he is. Don't tell him. Laura, thank you so much, Lauren, for the 4 months. I appreciate it. You guys are awesome. You guys are killing it right now. Alpapa for the 6 months. Happy year. That is awesome, Alpapa. Thank you. Thank you. You guys are awesome. You guys are awesome. I know you do it on purpose, man. It's cool. It's cool. No, you're cool, man. I appreciate you, Legal Fiction. Okay. All right. Now, yeah, I'm going to let it play out. We're going to see the sentencing, and then we're going to hang out with Meg's Crime Watch, and I will see you guys tomorrow. The Bengals play at 4, so my live stream should be on time tomorrow night, so I will be live tomorrow at the normal time. I know on Monday night they play not this Monday, but next Monday they play Monday Night Football, so I'm not going to be streaming that night. Sorry, guys. My my fandom to the Bengals will take precedence over streaming. So when they have night games, I will not be live. I'll try to do something earlier in the day, though. Maybe I'll go live earlier on Monday. We'll see. Depends on what I have. Okay, I'm gonna stop talking. We're gonna watch the sentencing and then go hang out with Meg. All right, you guys are awesome. Until next time, bye.
What is the mandatory fine?
The mandatory fine is $500,000 and the 25-year minimum mandatory as far as the sentence goes.
All right. Mr. Sum, does the state wish to be heard prior to sentencing?
I've calculated Mr. Frazier's jail credit at 407 days. As I stated, there's a 25-year minimum mandatory $500,000 fine. The state's asking for a 30-year sentence in this case, given Mr. Frazier's prior 4 felonies, the amount of fentanyl that he had in this particular case, as well as the extreme danger that fentanyl poses to the community.
Ms. McCarthy.
Sure, we'd ask the court to consider the 25 years. That's sufficient to take care of all the ills of the case.
All right, Mr. Frazier, do you wish to make a statement?
Okay. They'll see it my way. So,
Okay. All right, well, I am going to, it's my obligation at this time, since a jury of your peers has returned a verdict of guilty of trafficking fentanyl, and they made a special finding of 28 grams or more. It's my obligation now to sentence you. You'll be adjudicated guilty of trafficking in fentanyl, 28 grams or more. You'll be sentenced to 30 years in the Florida Department of Corrections, given credit for 407 days time served. And Ms. McCarthy, you agree with that amount, is that correct? Because my count was 405. I am going to assess fines and costs to be $1,078. And those include discretionary costs of $2 of local law enforcement education, a $65 assessment of additional court cost, a $150 discretionary public defender fee payment, $50 discretionary drug abuse fund, a trust fund, and a $200 discretionary fine. Those fines and costs reduced to a civil judgment. Based on the nature of the charges and the trafficking amount, I am going to assess a $500,000 fine at this time. That's also reduced to a civil judgment. Mr. Frazier, you have 30 days to file your notice of appeal. If you wish to appeal your judgment sentence, you'd like to have an attorney to represent you, and you cannot afford one may be appointed to represent you at no charge. Good luck to you, sir. You can step over and be fingerprinted. Okay. No, ma'am, not yet. Be back. Mr. Frazier, that's enough. Well, I'm sorry. Before we all go off the record, I forget. It's a 30-year sentence. There is a 25-year minimum mandatory based on the nature of the charge that's mandatory. Okay?